Welcome to both sides of the conversation to our educational Thursdays. Tonight we have a great presenter coming on tonight to talk about workplace rights. Tonight is an amazing topic. We know these type of topics we need in our community, and what a way to kick off our educational Thursdays with this brother Justin Ward coming on to educate our people. We reached out to him, and the first thing he said was, "If it's for my people, I'm coming on." And I got information for him. So just blessed to have this brother here. We know in these times that we're in, there's a lot of transition, a lot of things happening in this country, a lot of things happening in these institutions and these corporations. And sometimes the information is needed. And just want to say thank you for coming on, Justin, tonight to educate our people. And we're going to go ahead and just turn it over to you and let you get started.
My pleasure, and thank you for having me. So tonight I'll be discussing workplace rights. Now, I don't know that we're going to be able to get into everything because there's a lot of different areas of workplace rights. So we'll cover as much as we can in a reasonable amount of time. And then if we don't finish it today, we have, we can do it again, finish it another time. So a couple of things about me. I have been practicing law for over 17 years, about 17 and a half years now. I started out doing personal injury defense, and then I was a prosecutor in Los Angeles for 2 years. Then I was a prosecutor in Sacramento for 1 year before going out on my own in private practice. I have been in private practice basically since the beginning of 2008. And in my private practice, I focus on personal injury, employment, and criminal defense. So let's get started. Now I'm gonna try to share the screen. Hopefully that should work. Let's see. Okay, can you guys see that?
Yep.
Okay. So knowing your rights in the workplace. All right, let's see, let's try this. So in the area of employment law, it covers basically all of employee rights in the workplace. So employment law protects employees from discrimination, retaliation, harassment, misclassification of employee status, and wage and hour violations. And these are the areas that I'm gonna try to cover today. So first thing, with regard to discrimination. Now, what is workplace discrimination? Generally, workplace discrimination occurs whenever an employer takes an adverse action against an employee because of his or her protected status. And what is protected status? Protected statuses are disabilities, whether they be mental or physical, age, 40 and over. No, you're not old at 40, but your rights start coming into place once you're 40, or for age discrimination anyway. Gender identity, gender expression, sexual orientation, religious preference, race, color, medical condition, marital status, medical condition. Oh, I got that in there twice. Sorry about that. Military or veteran status. So whenever we're talking about protected statuses today, these are the areas that are protected. Other things like, being a 49er fan, not protected. Being a fan of something, liking certain locations, just those things that people get in arguments over at work, like what's the best ski resort or what's the best team, those aren't protected. So it discussed adverse actions. What are some examples? Undeserved discipline. You get suspended or you get terminated. You aren't promoted even though you should be. You don't get trained in a position even though you're qualified to be trained. You ask for leave, whether it be medical leave, sick leave, and they don't agree to that. You don't get hired. You have a disability and your employer doesn't accommodate it. You have a disability and your employer doesn't meet with you to determine whether or not there are various positions that you can do with your disability. These are the types of things that could occur that would be considered an adverse action. So what should you do if you believe that you've been discriminated against? So first thing is you got to keep a diary of any incidents of discrimination. You record the date, the time, the location, the parties involved, the witnesses, and details of the improper conduct or speech. That's key because your case may take place. You may have a lawsuit that gets filed 3 years after your last date of working there, or 3 years or 2 years after the conduct occurs. So you need to keep a diary. And with regard to that, you need to keep that diary in a, not in your work computer only, right? Because if you get terminated, they'll shut down your work email. You won't have access to your computer. So you need to keep this diary either handwritten or in your home computer, your home smart device, somewhere other than just at work. Second, review your company's anti-discrimination policy. Now, for those of you who work at large companies, you will definitely have an anti-discrimination policy. Those of you who work for a mom and pop type company, smaller companies, they may not have anything like that. But you need to review it to determine if the company, if it's in black and white, that these are the policies, these are the rules, and the company is not adhering to them, or an employee is not adhering to them. Number 3, and this is the main thing that you have to do. Make your employer aware in writing that you feel you are being discriminated against. If you don't let them know, then it prevents you likely from ever recovering compensation for the harm. You have to let the employer know what harm has occurred and give them the opportunity to correct it. If you don't, then it's not like you can just suffer through it and then hire a lawyer and then you sue and you tell the employer, hey, for the past year, this has been going on. Well, if they never knew about it, they didn't have a chance to fix it. And in most cases, you're going after the employer, not the actual individual employee. So you need to let them know. Number 4, let the employer know you're taking the matter seriously. Ask that a written report be made by the employer every time you report an incident of discrimination. Ask that an investigation be made into your allegations and that disciplinary or corrective action against the offenders be taken. Keep in mind that, yes, these are things you can ask for, you're legally allowed to ask for. That being said, you're not entitled to know what disciplinary action they take against the employee. That is protected. They don't have to tell you what specifically they do. Number 5, keep any objects or pictures which were posted, left for you, or given to you in the workplace that you believe were discriminatory. This was according to findlaw.com, a website. But, I had a case where an employee came to work and there was a noose on his desk, right? So take a picture of that, you keep that, that's evidence of something that's discriminatory, right? Or if there's a situation where you get a notice that you're being disciplined, make sure you keep that. Ask for it in writing so that you have proof of it. With regard to the situation, if it does not stop, right, after you've reported it, you've given the employer the opportunity, what do you need to do if the conduct doesn't stop? Contact a lawyer, like myself or another lawyer who does employment law. A lot of people say labor law. I mean, it's pretty much the same thing. The issue is that labor law is technically regarding unions, and employment law covers individual employees. But people use those terms interchangeably, so it's fine to use one or the other. But you contact a lawyer who specializes in or who focuses on employment law. The lawyer would then likely file a complaint with the California Department of Fair Employment and Housing. Of course, if this occurs in California. If it takes place in another state, not all states have their own departments of fair employment and housing or the equivalent. Some of them you have to go to the United States Equal Employment Opportunity Commission, or EEOC for short, and file your complaint there. And we'll get into that a little bit later. Or if your state does have its agency, whatever that name is, you go to them. You file a complaint with them, and then you can get a right to sue, right? They can either investigate for you, or you can have them give you an immediate right to sue, which you need in order to file your lawsuit. But don't worry, everybody gets a right to sue. I get people calling my office all the time. Hey, they gave me a right to sue. Well, I'm sure they did, because they give everybody a right to sue. It's just a step that the law requires everybody to, everybody has to go through that step first. Honestly, I think it's just designed to keep it, to make one more hurdle for people to be able to sue their employers. Because the employers, for the most part, don't even do anything when they get notification of your complaint, your DFEH or your EEOC complaint. Employers usually don't do anything. You get your right to sue notice, and then you can file a lawsuit after that. What are some of your remedies? State law provides for a variety of remedies for victims of employment discrimination. Back pay, which can include past lost earnings. Front pay, which is future lost earnings. Getting your job back. Getting a promotion. Out-of-pocket expenses. Ask for the company to change its policies. Get training. Reasonable accommodations, typically for a disability. Damages for emotional distress. Punitive damages. And that would apply to non-government employers. You can't get punitive damages against a government entity. If you work for the state, you work for the city, you work for the county, you're not entitled to punitive damages against them. Attorney fees. You can get attorney fees if you're the prevailing party in a lawsuit. And the thing that's good about that is that that gives incentives for lawyers to take your case. It gives them incentives to go to trial, because if they win, you get, and they spend hundreds of hours or thousands of hours preparing, they get that times their hourly rate, and that can be a substantial amount of money. The next area is harassment. Harassment and discrimination go hand in hand, or they're typically a lot of similarities between the two. There's two types of unlawful harassment: quid pro quo, this for that, and hostile work environment. Quid pro quo, or this for that, it generally results in a tangible employment decision based upon the employee's acceptance or rejections of unwelcome sexual advances or requests for sexual favors, but it can also result from unwelcome conduct that is of a religious nature. Like, hey, come to church with me, or are you willing to go to church with me? If you go to church with me, I'll do this, or I'll do that. Or if you don't go to church with me, we'll do this, or we'll do that. This kind of harassment is generally committed by someone who can effectively make or recommend formal employment decisions, such as termination, demotion, or denial of a promotion. So this is typically a supervisor of some type, or someone who is in favor or has a close relationship with a supervisor, and they have the ability to affect the victim. I mean, unfortunately, when you hear about the Me Too movement, right, that took place, a lot of that was workplace things. You heard about Fox News and Roger Ailes. That's exactly what this would be considered, what that would be considered, quid pro quo. If you have sex with me, I'll get you on the air. If you have sex with me, I can get you a raise, things like that. That's quid pro quo. Couple examples: you get fired or denied a promotion for refusing to be sexually cooperative. You get fired or demoted, or you won't get hired unless you can go to church with them or go to synagogue or whatever religious services they have. They offer, a supervisor says, hey, look, if you're willing to, start dating me, I can, make things a lot easier for you here at work. I can get you a promotion. I can get you a better office. And unfortunately, that still takes place today. Hostile work environment is a little bit different. I mean, obviously, sexual harassment is definitely hostile, but this is non-sexual typically. So a hostile environment can result from the unwelcome conduct of supervisors or coworkers, customers, contractors, or anyone else with whom the victim, the employee, interacts with on the job. And the unwelcome conduct renders the workplace atmosphere intimidating, hostile, or offensive. So when does it become illegal, right? Because I mean, we have harassment, people saying, oh man, I can't believe you're a 49er fan. The 49ers are terrible, and you're an idiot for being a fan. That could be harassing, but that's not what we're talking about here. So in order for harassment to be unlawful, to be illegal, it must be unwelcome and based on the employee's protected status. Remember when I discussed those earlier? Age, race, gender, sexual orientation, religious preference, those types of things. So it's unwelcome, meaning you don't want it. It's based on your protected status, and it has to be subjectively abusive to the person affected. What that means is that you have to feel that it was abusive to you. It also has to be objectively severe and pervasive enough to create a work environment that a reasonable person would find hostile or abusive. What's that mean? Basically, the average reasonable person in that situation would have had to have felt that it was hostile or abusive. If you're a person that is overly sensitive, then things that occur may not be harassing to the average person, even though they are to you. Some people, we all know some folks, and we may be those folks who are just more sensitive to jokes, more sensitive to comments, more sensitive to criticism. And if you're hypersensitive, then yeah, that's subjectively abusive, but it's probably not objectively abusive. And so in order to determine whether the harassing conduct is severe or pervasive, it's determined on a case-by-case basis with consideration paid to the following factors: the frequency of the discriminatory conduct, the severity, how severe is it? Whether the conduct was physically threatening or humiliating or a mere offensive utterance, right? Somebody saying, that dress don't look good on you, or that's an ugly outfit. Your makeup is bad, or man, that's a bad toupee. That would be offensive, right? An offensive utterance, but it's not physically threatening. Yes, it would be humiliating. So, it may apply, but like they said, it's taken on a case-by-case basis. Whether the conduct unreasonably interfered with work performance. Are your coworkers harassing you so much that you can't get your work done, that you can't concentrate? If that's occurring, then this might apply. The effect on your psychological well-being. I mean, there have been cases where somebody was tormented by coworkers who were threatening her. The women were, kind of cornering her in the bathroom, saying rude things, talking about fighting her and beating her up. I mean, that could affect you psychologically if you're constantly worried you're going to get assaulted. And whether or not the harasser was a superior. Keep in mind, that's not required. The harasser can be a subordinate. The harasser can be a contemporary, somebody of equal position, or it could be a superior. But these are some of the factors to consider. Protected status, we went over that earlier, those things I mentioned earlier. So what do you do if you feel you're being harassed? It's very similar to the discrimination. You know, you keep the diary of the harassment. You keep any objects or pictures which you find harassing, or take pictures of them, right? Make sure your employer is aware in writing that you feel you are being harassed, and let them know about what the conduct is. Let them know you're taking it seriously. Ask that they make a report. Basically the same things as the discrimination. Also, if it doesn't stop, same thing as when you're being discriminated against. Contact a lawyer, or you can file a complaint with the DFEH or the EEOC, and then get your right to sue, file a lawsuit. How do you report harassment, right? A lot of people wonder, what do I do? If you believe you're a victim of harassment at work, you need to report it to the employer. That's going to be typically to your human resource department if you have one. If you don't have a human resource department, then you report it to your supervisor. Of course, the next question is, what if my supervisor is a harasser? Well, he or she will have a supervisor, and you need to report it to their supervisor. If in some cases this is a small company and there's no human resources, and the head person in charge, the CEO, CFO, president, is the one doing the harassing, what do you do? Well, in that case, you have to report it to a subordinate of theirs, right? Somebody who's in between the two of you, a superior of yours. You still got to report it. You have to put the company on notice. Also, you have to, in those cases, if you can also tell the supervisor, make sure you tell them, and you do it, of course, as I said earlier, in writing. You want a paper trail of your complaints, a paper trail, a documentation of what you've done to get the employer to correct this problem. In terms of filing the complaint, right? When you file a complaint, this is, at the job, you're protecting your own rights and yourself, right? Because if you don't file the complaint, if you don't report it, then you're really preventing yourself in the future from being able to sue and recover damages, from being able to get the employer to correct their habits, to correct the problem, to get rid of that problem employee. Retaliation. So retaliation is discipline or discharge because of something the employee said or did. Some examples: being terminated, being demoted, having your hours reduced, being reassigned to a lower paying position, being reassigned to a position that pays the same but is less desirable. I mean, maybe you went from being a receptionist or being a paralegal to being a receptionist. Well, now you're just answering phones. You're not really using your skills as much, but they paying you the same. Well, that would still be, or could still be, retaliation if they did these things to you in retaliation for something you said or did that was protected. Acts against third parties close to the employee. For instance, if your spouse works with you and they terminate your spouse in response to you exercising your rights. Well, no, they didn't harm you, but they harmed a third party that was close to you. That would still be illegal retaliation. Some of the conduct that would be examples of conduct, that employee conduct that's protected. If you complain about safety or health conditions in the workplace, for instance, we're in the age of COVID right now, right? So if they don't force employees to wear masks, well, that's protected. That's employee safety. If you work at a facility or a place that has bathrooms, right, which we all typically would, right, and they don't keep the bathrooms clean, they don't keep the bathroom floors dry, always by the sink there's water on the ground where somebody could slip and fall, you report that. That's protected. If you refuse to perform work that would violate any occupational safety or health standard, if there's a whole lot of things that could apply. One example, if you work at a hospital and they want, you're a nurse and they want you to prescribe medication, which you're not allowed to do unless you're a nurse practitioner, right? So you're doing something that's not safe for you to do. Or if you're a medical assistant and they're trying to get you to insert IVs, right? When that's not within your expertise, that's not safe. If they are not sanitary at the workplace, that could lead people to get sick. If they're not following rules and regulations, that is something that's protected. If you report it, that is protected. If you complain about harassment or discrimination for yourself or that you see occurring to another employee, that is protected. So these are the types of things that if you report this, if you do these things, these are protected. Now, does that mean your employer won't fire you or won't retaliate against you? No, that's not what that means. What that means is that if they do it, they are breaking the law. And therefore, you have recourse against the employer. And I'm sure, as most of you know, this type of thing, employees get disciplined for exercising their legal rights all the time. Now, there are plenty of things that employees do or like to do that is unprotected. Some examples. If you complain that a supervisor is micromanaging you, you complain to HR. Well, guess what? If a supervisor micromanages, that's not illegal. That's not against any employment law. And so if you complain about it and you get disciplined for it, well, there's nothing, you're not protected for that. If they give you an assignment, let's say, hey, you're a police officer and you're assigned to go work in a bad neighborhood and you say, I'm not going there. Well, sorry, sir, that's your job. Sorry, ma'am, that's your job. That's what you got to do. I'm not going. You're fired. Well, that was on you. You didn't want to do that job. You didn't want to do that assignment, but you don't have a right to perform that, to do that. If you're talking to your coworkers and getting into people's personal business, asking about it, that's not protected. If you're gossiping at work about other employees and you get disciplined, you get terminated, you get suspended, that's not protected. The areas that are protected, we discussed earlier, these types of things which occur all the time are not protected here. Retaliation. And so what can you do if you believe you've been or are being retaliated against? Similar, as we talked about some of the other things, you keep the diary of the retaliation. Obviously, if you're terminated, you're not really going to be continuing to keep a diary because you're not working there anymore. But make sure you write down everything you can think of if you haven't been doing it. Make the employer aware in writing that you feel you are being discriminated, that you're being retaliated against. Let them know you're taking it seriously. Ask for an investigation. Steps to take if you're a victim of retaliation. You file the written complaint with your human resource department or your company if you're still working there, right? Obviously, if you're terminated, it's not going to do you much good to file a complaint about your termination because you're no longer working there. The other steps of the DFEH. Now, with retaliation, the California Labor and Workforce Development Agency, or LWDA, or a lot of people just call it the Labor Department. You can contact them. They deal with retaliation as well as the EEOC. Another area where employees are employee rights is misclassification. This is typically in the contractor versus employee status. So the US Supreme Court has on a number of occasions indicated there is no single rule or test for determining whether an individual is an independent contractor or an employee for the purposes of the Fair Labor Standards Act. But the court has held that it's the total activity or situation which controls among the factors. And so this is determining whether you're, a W-2 employee or you get a 1099, right? The W-2 employee, the employer has to pay benefits. You're entitled to sick time, workers' compensation if you're injured. All of those rights apply. When you're an independent contractor, they don't apply. And one of the things employers do oftentimes so that they don't have to pay benefits is they keep people as independent contractors when technically they are actually an employee and they're supposed to be paid like an employee. Some of the factors to look at: the extent to which the services rendered are an integral part of the principal's business. So this is something the business can't do without probably an employee. The permanency of the relationship. How long has it been going on? How long has it been going on? The amount of the alleged contractor's investment in the facilities and equipment. How much are you having to go into the office? How much are you using the company's equipment? The nature and degree of control by the principal. Basically meaning, does the employer always tell you everything to do, what to do? Are they trying to micromanage you when you're supposed to be an independent contractor? Your opportunity for profit and loss. Do you have the opportunity for profit and loss? Meaning, are you getting a percentage of the company's profits? Or is this like a sales job where your profit is derived upon how much you sell? The amount of initiative, judgment, or foresight in open market competition with others that's required for the success of the claimed independent contractor. Basically, how much of your own judgment, how much of your own initiative, of your own efforts matter with the job that you're doing. And then the degree of independent business organization and operation. How independent are you from the employer? Do you make your own hours? Do you make your own location? Do you, pretty much get to dictate kind of what you do to a certain extent yourself? There are certain factors which are immaterial in determining whether or not this is an employment relationship as opposed to a contractual relationship. Such facts are where the work is performed, the absence of an actual employment agreement, whether an alleged independent contractor is licensed by the state or local government. Those aren't considered to have a bearing on the determination. Additionally, the Supreme Court has held that the time or mode of pay, so how many hours you work, or are you paid with a check, are you paid with cash, those don't determine whether you're an employee or not. Wage and hour violations. This occurs way more often than you think it should. What does that mean? That's non-payment of wages or payment of or lack of payment of wages, right? You don't get all the wages you're supposed to. Non-payment of overtime, non-payment of vacation pay. You don't get meal or rest breaks. Non-payment of wages, you worked for certain hours and you didn't get paid. The employer has you performing work tasks but doesn't have you pay for them. I don't know if you heard about the lawsuit a couple of years ago where there was a class action against a coffee company, a major coffee company, where they were having employees clock out before they did the final closing or closing of the store. So you would clock out, then close the store, then lock the doors and you didn't get paid for that 5 minutes. Well, 5 minutes isn't a lot in and of itself, but 5 minutes every day, 5 minutes every day for, 5 days a week, 52 weeks a year, I mean, that adds up. And they had to pay. I mean, they didn't get that much money because it was, 5 minutes a day, but over the course of years, I mean, ended up being thousands of dollars. Plus there were penalties. If the employer requires you to attend certain functions or events, but doesn't pay you for going to those events, if they have if they have a mandatory employee meeting, a staff meeting, if you have to go there, they have to pay you. They have those Saturday morning meetings at the store, they have to pay you for that. If an employer requires you to be available, meaning you're on call, for instance, but doesn't pay you for that time, that is a non-payment of wages. Also, you have to get at least the minimum wage. So an employer can't say, look, I'm going to pay you a daily rate of $50. But then they have you working 10 hours. Well, that's $5 an hour, right? That's below minimum wage. So that's not legal. Non-payment of overtime. You get overtime, for those of you who don't know, 1.5 times the employee's regular rate of pay for all hours worked. All hours worked in these circumstances: over 8 hours per day, up to 12 hours, or over 40 hours per work week. Now, keep in mind, you don't get both, right? You don't get time and a half and then time and a half again. If you work 9 hours one day out of the week and that puts you at 41 hours, you're not going to get overtime for both that extra hour over the 8 and over the 40. You don't get both. Additionally, if you work more than 6 days in any work week, this is full-time days, you get overtime. So if you work more than that, basically that 7 days, right? That 7th day, you get overtime for that 7th day. And on the 7th day, you get time and a half for that first 8 hours of that day. And then what we have after that is double time. So if you work more than 12 hours in any work day, that's double time. If you work more than 8 hours on the 7th consecutive day in a work week, that's double time. There are certain exceptions. Exemption does not apply. So there's certain jobs where it does not apply. For instance, if you know nurses typically work, they work 12-hour shifts, and then they do that 3 days a week, 1 week, and then they do it 4 days a week the next week. For at least the nurses I know. Well, they're not getting overtime for those 4 hours extra they work. That's how the nurses' shifts are scheduled, and so they have an exemption basically. And there's other professions that have different rules as well. If you're a daycare provider, not daycare provider, I'm sorry, but like a group home employee, and you stay overnight, there's different rules. We're not going into all those separate rules, but there are different rules for those types of employees. Meal breaks. So under California law, employees must be provided with no less than a 30-minute meal period when the work period is 5 hours or is more than 5 hours. And if you're in the motion picture industry, there's one exception if it's more than 6 hours there. Unless the employee is relieved of all duties during the entire 30-minute meal period and is free to leave the employer's premises, the meal period shall be considered on duty. Meaning, if you have to work at your desk when you eat your lunch, that lunch period is paid. They still have to give you that 30 minutes, but it counts as hours worked, and you still get to eat your lunch during that time, but they have to offer that. And so an on-duty, right, meal period will be permitted only when the nature of the work prevents the employee from being relieved of all duty, and when by written agreement between employer and employee, basically, if you agree to it, if you agree to have a working lunch where you'll get paid for your lunch, but you're allowed to eat at your desk, you can agree to that, but you have to agree to it. They can't just force you to do it. Unless, well, yeah, no, basically you have to agree to it. An employer is not required to ensure that no work is performed during your lunch break or your meal. They call it a meal break because it could be dinner, I guess, or breakfast, depending on what time. The employer doesn't have to make sure that you take your break, but they have to do more than just make sure that the period is available. I'm sorry, the employer doesn't have to make sure that you don't do any work, but they do have to make sure that they do more than just make sure it's available. Let you know that, hey, it's your 30, you got your 30 minutes. They've told you about your break. They've let you know. They've made it available as well, meaning, if you work at a job that says no employee, you can't leave the store alone unattended, right? Well, if nobody comes to relieve you, they have not given you your lunch break. In general, to satisfy the obligation to provide a meal period, an employer must actively relieve the employees of all duty, relinquish control over their duties, permit them a reasonable opportunity to take an uninterrupted 30-minute break, and must not impede or discourage employees from taking their meal period. They can say, wait, you're taking your break? Really? Why? We got work to do. They can't do that. Rest breaks. In California, the law requires that employers authorize and permit non-exempt, obviously. So we didn't go over exempt versus non-exempt employees, but basically exempt would be, usually it's an employee that is in a higher position, a supervisory role, management. Our management is always exempt employees. They're not the same. They're not hourly. They're paid on a salary. So the law requires that employers authorize and permit employees to take a rest break in the middle of each work period. So if you work 8 hours a day, so after the first 2, you get a 10-minute break. And it's based on the total hours worked daily and must be at the minimum rate of a net 10 consecutive minutes. And it's funny, everybody talks about 15. I always thought it was 15. It's actually 10. So 10 minutes for each 4-hour period or major fraction thereof. There are exceptions that apply to certain professions. Truck drivers, for instance. What do you do if you feel that your meal or rest break rights are being violated? You need to inform your employer, give them the opportunity to correct the problem. One, how's that correct the problem? Well, one, that would be making sure you get your breaks, your meal breaks, your rest breaks. 2, paying you for the breaks that they did not allow you to have previously, right? So you've reported it, they didn't take care of it, they didn't make it right. What do? You can file a claim with the Labor Commission of your state. If you have to do it within 1 year, if this is regarding a company bounced a check and didn't give you another check. If you ask to get a copy of your payroll or personnel records, you have 1 year to file a claim about that as well. If you're given an oral promise to pay more, if they promise that they're going to give you a raise or pay you more than the minimum wage, you have 2 years to file suit over that promise. Let's say, hey, I'm going to hire you to work at my office. I'll pay you $20 an hour. That's more than minimum wage. And then I don't pay you. Once I stop paying you, or once when I say I'm going to pay you and I don't, You have 2 years to file a claim with the Labor Commission for me not paying you what I said I would. If it's minimum wage, whatever, that is in your state, well, I guess we're talking about California. If it's minimum wage that you're not getting, you have 3 years to file a claim for that. 3 years to file a claim for not getting paid overtime or unpaid rest or meal breaks, sick leave, illegal deductions from your pay or unpaid reimbursements. You go on a business trip, you submit your receipts and they don't pay you for that. You got 3 years for that. If you have an employment contract, which some employees do, you have 4 years to file suit for that. Deadlines. If with regard to harassment, discrimination, retaliation, if you're doing this in California, you have 3 years from the date of the harm to file a complaint with the Department of Fair Employment and Housing, and then 1 year to file a lawsuit after you file your Department of Fair Employment and Housing complaint. If you file with the EEOC, you have 6 months from the harm to file with the EEOC. That's extended to 300 days in certain exceptions. We're not going to go into all that, but if there's an exception, you'll get to 300 days. But remember, it's not 1 year if you want to do it federally. I mean, I would tell you this: if you're in California, unless you're a federal employee, you want to file with the Department of Fair Employment and Housing. The laws are better. You have more time. After you file your EEOC complaint, you have 6 months to file your lawsuit. And as I said, there's different rules for federal employees. We're not going to get into that today. Cover that. Oh, wait, did we cover it? Let me see. Yeah, covered that. Retaliation. You file with the Labor and Workforce Development Agency 1 year from the harm to file a Private Attorney General Act lawsuit. Basically, that's a law that allows you to file suit on behalf of employees who are harmed. You have 1 year to do that. You also have 1 year to file your notice with the LWDA, which you have to do. Remember I talked about earlier. There's certain requirements. In this case, you have to file a notice with the LWDA that you're going to file the PAGA lawsuit. You have 1 year for that. You also have to give the LWDA 65 days to investigate. So the main thing is don't wait, right? Because you may miss your rights. After the LWDA's 65-day period expires, you have 60 days from that to amend your lawsuit. What that means is you have to get the lawsuit filed within the 1 year to do the PAGA lawsuit. And then after the LWDA, if they decide that they're going to just let you go forward and they're not going to do the PAGA case themselves, you can amend your lawsuit to add this on there. And that's all. We're going to be opening up for questions. My contact information is here. My office is in Sacramento, in the Natomas area. Here's my office number, my email address, and my website. So with that, I'll turn it back to John Henry, and we will entertain any questions if there are any.
All right. I'm sure we have a few questions. We have a lot of people watching. We always on our Educational Thursday, the last couple of months, we've been struggling with the football season. Our viewership is down, but on the replay, I'm glad you put the information up there so that people can reach out to you, because I'm sure there's going to be questions and follow up. And I'm glad you kind of went over the rules and breaks. I know one of the struggles here at both sides of the conversation, we're definitely trying to educate our Black and Brown community and working with some of the Latino workers. I know a lot of time is fear because of sometimes citizenship status. What can they do when they have issues? Because I know a lot of times they like, oh, I don't want to say nothing on some of these things of workplace harassment or being threatened to be terminated, and kind of just deal with, sometimes a manager or boss, harassing them or doing something like that.
So when you said that, are you talking about people that are undocumented, or are we talking about in general?
In general and undocumented, or maybe have like working green cards.
Okay, so when it comes to undocumented workers, well, there's a couple of issues there, right? Because one, if you're undocumented, typically or oftentimes you may be working under a false social security number, right? Because you got to have a social security number. Now, that is a criminal violation of the law, right? So you got to, and I've been involved in those situations. So there is a risk there. I mean, yes, there's a risk that you can be prosecuted criminally for social security fraud, right? Because the person whose social security number that is supposed to be paying taxes at the end of the year, on those wages, or and you're getting paid, and so there's a whole bunch of issues with that. But that being said, the law does not allow employers to treat you differently based on your documented or undocumented status, for the most part. Obviously, the police department is not hiring somebody that's undocumented, right? I mean, you can't. There's certain you're supposed to be documented. That's the rule. But if you are undocumented and you are working for an employer, they're not allowed to discriminate against you. They're not allowed, the things we talk, they can't harass you. They can't retaliate against you. They can't discriminate against you. The laws still apply. I know some people aren't happy about that, right? Why do the laws apply to them? They're not supposed to be here. We don't allow that. You don't get to murder them. You don't get to harm them. You don't get to do them wrong just because they're not documented. The law doesn't allow for that. So with regard to undocumented workers, you have the same rights for the most part, as a regular employee. Now, yes, you likely would be terminated because you're not documented, you're using the false social security and all that. So there is a risk, but it doesn't mean you couldn't still sue them. It's a little tricky, right? It's a little tricky because you got that social security issue and you're getting paid, and now they're going to stop paying you. So technically you have those rights, but you will still get terminated. I mean, you're not getting your job back. You could get some benefits, right? You could file a lawsuit and get some money, but you're out of that job for sure. That's the main thing people are worried about, right? Is losing their job. Well, the law says the law can't prevent an employer from doing whatever they want to do to you. It can't prevent them, right? It can punish them if they do something they're not supposed to do. That's what the law does, right? People say, well, if I report that my boss grabbed my butt, they may fire me. They're legally not allowed to. And very well, yes, they might do that. If they do, that's wrongful termination, that's illegal, and you go after them. There is no notice on that situation, right? You don't have time to give the employer notice because they fired you. I told you about him doing this to me, and then you fired me. So that's immediate. That's not, hey, you didn't give your employer notice. You tried to give your employer notice of the harm, and they took the harm to another level. They fired you for it.
Justin, can I ask you a question?
Of course.
So, number one, after listening to you, I feel like I should be on some island somewhere because I've had enough of them that I definitely should have been somewhere. But as a woman, and I know that, for some women in particular, being pregnant is definitely something we always struggle with, telling our employer how that is. I know for me personally, I was young. I was young when I had my son, and I was at a job and I was getting tired. Tired, and I didn't do something one time, and then I did it, but she wrote me up for it. And I'm like, I didn't tell anybody I was pregnant because I was, worried about that. But push come to shove, she wound up leaving. It was a whole nother situation. But as a woman and being pregnant, what kind of protections do you have? In terms of when you tell an employer, or, is it, once I tell an employer, now I'm more protected because
Yes.
they're aware of my situation, and, can they fire me? What can what protection do I have as a pregnant woman, so that I don't get fired? I'm not scared about losing my job or taking a little bit more leave, those kind of things.
So earlier when we talked about the protected status, right? Medical condition, right? I mean, pregnancy is covered as a medical condition. And so, and as most people know, there's very varying types of pregnancy. Some people, they go through 9 months, no issues, no morning sickness, no issue. They just take their prenatal vitamins, easy 9 months. Other people have to go on bed rest, right? And then you have everybody else in between. So legally, your employer cannot. I have a case right now where I'm representing somebody who was terminated shortly after she explained that she was pregnant, and then asked for accommodations. I talked earlier about a reason, accommodations in the interactive process, right? So you're letting them. You have to let them know about the condition. You were falling asleep. You didn't let them know. You fall asleep at most jobs, you can get terminated, right? Because now if you have narcolepsy, or you have sleep apnea, I think narcolepsy, you can't sleep. So you can't sleep at night, but you may fall asleep in the day. And then you have other conditions that may make you tired, or you have to take certain medications. You have to let your employer know, and you also have to provide documentation, right, from your doctor, not explaining all details. Hey, I have narcolepsy. I have this. No, Justin Ward has a medical condition which necessitates that he gets A, B, C, and D. Or due to this medical condition, he has periods of time where he may fall asleep. As such, we recommend this. Like, you have to get something from the doctor. You don't have to tell them all your business, right? Somebody has HIV, they don't got to tell the employer that they have HIV. I mean, well, most employers you don't, right? If you're dealing with hands-on and you could be cut and bloodied, you got to obviously disclose that. But for the 99% of professions, you don't have to tell them. So you have to give the employer notice. You can't just, I start falling asleep. Oh, hey, by the way, I'm pregnant, right? No, they didn't fire you because you're pregnant. They fired you because you fell asleep. And if they knew you were pregnant, then there was things that could be done. So it is protected. Being pregnant is protected. And actually, when it comes to women that have children, right, there are laws, right? I didn't put that. You got the FMLA, the Family Medical Leave Act. You have the California Family Rights Act. Those provide protections with CFRA, the California Family Rights Act. That applies, I believe it's 50, you have to have 50 or more employees in California for that to apply. And that gives you enhanced protections if you have certain medical conditions, or you have family members with those conditions. I know people that, their father had to have surgery, had to have transplants, and so surgery. And so she was the only one that could take him to his appointments. She needed to be on call in case he got a call for the transplant. So she would go and be able to go and get him. So she had that in their thing, like, I have to take intermittent leave because of my dad. Now, that doesn't mean you get paid for that leave. It just means your job is protected. And of course, if you have vacation or sick time, you're allowed to take it for that leave. But if you don't, you're allowed to take it, leave without pay.
So really what I'm hearing is you need to let them know.
Correct.
Because once your employer is aware that you say you're pregnant, that, okay, now you're protected. Like when I had again, I was younger, had that incident, it was, they didn't know at first. Because again, I was 19, I was young, kind of scared, wasn't quite sure what was going on. And then, I told, and then it was like, oh, okay. But, it really sounds like letting them know so that if there is any retaliation or repercussions, you've let them know and it is a protected status.
Correct.
And another question I have is also, again, at that point I was young, there's a lot of things that our youth and our young adults think that's okay. I'll just let that slide. I'll just let that happen. Um, I mean, I've been where I've been at a union job and I've been harassed. I was 16 and I was harassed by somebody that was 40 that was sexually harassing me, the owner
Right.
knew, all that kind of stuff. You know, what kind of advice do you give to these young adults, young, you know, what do you give to them to say, hey, it's okay to do this? Because I hear, you know, I didn't know. I mean, I want to go into HR, you know, go into the union. I learned all that kind of stuff that, like, oh, that man, you should have been kicked out. I should have been paid ransomly. You
You're
know,
right.
what do you say to these young adults that say, hey, you don't have to be harassed. You don't have to take it, because they are taking advantage because you don't know.
Well, I mean, what I would say is this, when we're young, we don't know everything, right? I mean, a lot of things, just whether it be at work, whether it be just in life and society. I mean, there's conduct that occurs in households. We just don't know when you're young. What I would say to anybody who's an employee, if you have children who are employees, if you think something wrong is going on, you tell somebody else, right? And not your peer, right? You tell somebody who is your elder, right? You tell a parent. If your parents aren't very sophisticated or not, you tell a teacher, you tell a neighbor, you tell a relative, somebody who you feel has some life experience that maybe can give you some good advice, right? I mean, you probably don't want to talk to your grandparents because, back in their day, people would get hit by by supervisors and, for doing stuff wrong and nothing happened, right? They made, back in their day, they tolerated a lot more than get tolerated now. But you got to talk to somebody. And when in doubt, call a lawyer, right? I mean, if you want a full sit down, type of consultation, that's probably going to cost you in employment law. But if you call an employer and say, hey, um, I'm 16 and my manager is trying to get me to have sex with him in the break room, what do I do? Or is there anything I can do? Right? That attorney is going to be like, I'm sorry, what'd you say? Oh, okay. Here's what we need to do. You need to come in the office tomorrow, and we need to get you signed up because we're going to go and we're going to get paid. I mean, I had a family friend who came to me later, right? It was out of state, but later worked at a fast food place underage. And this manager was making sexual innuendos and, and we could have, but I didn't know about it. You know what I mean? And they kind of wanted to handle it, in the streets, which we didn't cover this in the presentation, but you can't handle it in the streets. You can't have your brother come and put hands on the supervisor. You just can't. As much as you want to, you can't, right? Because yeah, you're going to feel good about it, but you're going to get fired. You're not going to get paid, right? And somebody may get arrested. So could you be calling an attorney for a different reason? So handle it properly, right? Call the lawyer, let them know what's going on. If the lawyer, and one thing I didn't really address, but I need to mention, if there's a harm that's occurring, but lawyers feel like, you know what, this isn't worth it for us to take financially, right? Yes, what they did was wrong, but you quit that job and you got a job paying double the wages, the next month. So you have very little lost wages. In fact, you have a better job now. The harm, yeah, he held your hand too long, but he didn't grab you in the, your sensitive parts. He was inappropriate, but he wasn't so inappropriate that it has a lot of value. Well, if those situations occur, you could still report them to the DFEH, to the EEOC, and those state agencies, those government agencies can investigate for you, right? And those are there's cases people call me about. I'm like, yeah, you were harmed, but I just don't. The financial value isn't there for me to get involved. Maybe you have the DFEH investigate, and they will try to get the matter resolved, and that could include getting your job back. It could include getting you a promotion. It could include getting you back pay, future pay. And they do that. Of course, it's going to take a lot longer dealing with them because they just have, they're a state agency, a government agency. But that's also something that can be done, even if lawyers turn your case down. So don't feel that you have to get yourself a private attorney. The government agencies can also do it for you.
And I know you talked about, you referenced California. I worked for an employer one time where they were based in Michigan, but I was in California. So is that something that if I had an issue with them, that I would need to find somebody in California or that would definitely be able to help me? Or should I look for somebody, would I have needed to look for somebody in Michigan?
So it varies, right? If it's not all about where the company is based, it's in part, where does the company operate, right? Like, for instance, like Walmart, right? Walmart is headquartered somewhere in the South, I think, or the Midwest, like Alabama, or one of those states, right? But they have stores all throughout the country, right? You don't have to sue Walmart where Walmart is incorporated, right? You could sue Walmart in your state. Now, what very well could happen is, and I've had this happen a couple times, if the employer is, you sue where the harm occurs, basically, right? What the employer has a right to do, if the value of the case is over $75,000, they can remove it to federal court. It'll be at the federal court in your jurisdiction, right? Like in Sacramento, we have the Eastern District of California, so it'll be heard there. It's not going to be heard in court in Georgia or Alabama. It'll be heard where it occurred, but in federal court, and they could do that. They have a right to do that because of where they're incorporated.
Right. One other question that I had when you was talking about wages, and I know you was talking about people that work for city and counties or state. One of the biggest issues when we talking about state workers and then unionized workers working for state or city entities, there's been a common practice, and I just wanted to see if you could speak to it. How a lot of union employees feel that there's loopholes in the law when it comes to when you talked about the time and a half and the double time because of the collective bargaining agreements, right? So what's happening is a lot of unions are not so much the union, but the employers for city and county or a state, they get through the loophole of, because you have a collective bargaining agreement, it overrides the state and federal laws, right? So sometimes what
Yeah.
ends up happening is there's union contract or collective bargaining agreement language that doesn't meet the minimum of the federal and the state requirements. Is that legal, or how do you address that?
Okay, so there are certain, and I don't know every aspect, right? I mean, that's kind of that's a huge question, right? Your main question is can you contract out of state and federal law, basically, right? If your collective bargaining agreement, I don't believe that your collective bargaining agreement can agree to receive less than the minimum wage, right? I don't believe that that's allowed. I couldn't point to the law. I've never dealt with that. I've never heard of that, people trying to do that, right? With regard to, there are exceptions, right? With regard to overtime, with regard to sick time, with regard to certain types of behaviors. Let's say, for instance, you work at a radio station, right? And it's a comedy station. Or let's say you're a comedian, right? And you work for a big comedian. You work for like Kevin Hart, right? Well, obviously, if Kevin Hart makes fun of you, like on the radio show, he makes fun of you. He talks about your certain things that are protected, right? Your gender, your sexual orientation. You can't sue him for that, right? Because that's the nature of the business, right? So obviously a boxer can't, if your trainer, punches you, right, in a training session, a sparring session, you can't sue the trainer because he punched you. You can't, you know what I mean? Like, so there's exceptions. I don't know the answer in terms of, I believe you could contract for things that make you the exception with regard to what the normal law is. I don't know all those exceptions. I do know they can apply to meal breaks. They can apply to rest breaks. They can apply to overtime. There are rules with regards to that they can do. But I don't know all the specifics on that.
Okay, no, that was fine because I know just a lot of people. I know a lot of union workers, and that's one of the biggest things. Like their contractors say they only get to get time and a half. So even if they work 18 hours, they only get time and a half. But the state law says, hey, if you work over 12, it's double time or things of that nature. I think that's where I was trying to.
So those are legal, basically, for the most part. I mean, there's certain things that they probably couldn't do. Things like that is legal. Like for instance, prison guards, right? CO, correction officers, they'll work a double, right? They'll work 8 and they'll work another 8, but they're not getting double time, right? They're not getting double time because they're like, it's typically like, hey, I need a vacation or I need time off next week. So I'm going to switch with you. I take over your 8 and you're going to work mine next week. I don't get double time and overtime for working your 8. I made that voluntarily. You know what I'm saying? I do know that.
And one other question I wanted to talk about. I know you were saying earlier about the documentation. You were saying something about the employer can hold the email, send it. I kind of missed a little bit of it, but so in the construction industry, I know a lot of people in the construction industry, and typically Black and brown workers are affected the most by the union contracts and the contractors, right? So typically a lot of those things that you talked about, protected workers, a lot of times affect the people in the construction industry, and typically they just get laid off. So they just uh, so how does that work for those employees? Because a lot of times they could just say, hey, a person can make that complaint and say, hey, I'm being harassed out in the field by X, Y, and Z. And then, they could just say, hey, we'll lay you off. We could say slow work. Or how does those workers under those conditions protect themselves in a sense?
So, I mean, keep in mind, most employers, if they're firing you if they're retaliating against you, they're not going to say, hey, John Henry, we're firing you because, you complained about, Bob calling you this or calling you that, right? They're not going to say it, right? They know better these days, right? You know what I mean? Back in the day, they bring you in, hey, you know what? You complained about him calling you this or that. You know what? So we're letting you go out of here. They know better these days. They'll say, hey, there was no work involved. Like my client who was pregnant, they came up with a lot of excuses. They didn't say, well, they said your work is slowed down and whatnot. And then even in the deposition, they said, oh, it had nothing to do with her pregnancy. It was her work. And, we wrote her up. Interesting, because you gave her a raise. Just shortly, you gave her a raise despite these things that you said she was doing all wrong. I'm trying to understand, why'd you give her the raise, right? That doesn't go together. And this is for people who are employers, right? If you have an employee who is messing up, who you're not sure about, do not reward them if you're debating on whether or not you're keeping them. Because if you reward them and then shortly thereafter you let them go, it's going to look like, wait a minute, what happened, right? Because maybe you were looking at, maybe you're going to let them go, right? And you don't. And then next thing you know, they go out on stress leave. Well, now you can't fire them for going out on stress leave, right? That's retaliation, right? Or they end up pregnant. Now you were going to let them go anyway. And guess what? You kept them around. You gave them that raise. Now they got pregnant. And now you fired them. Now it looks like you fired them because they were pregnant. It very well may not be because they're pregnant, but the timing is horrible, and you're gonna have a problem defending that in front of a jury. But being more specific with regard to your question, I mean, if you feel something's wrong and then you report it and they terminate you, then you sue them, right? I mean, that's what you do. You have no, that's your recourse, right? Your recourse is to sue. And maybe they pay, maybe they don't. I mean, I represented somebody recently. We got a good settlement on a case. I mean, he was harassed, right? Racially. There were multiple incidents. I mean, they even agreed that some of the stuff occurred. They thought, well, yeah, it's outside the statute of limitations, right? Well, what I let them know, like, look, it's a continuing violation, right? If you can look at past allegations, past conduct, even if it's outside the period of time, the evidence comes in and the jury would hear about it. So when a jury hears that your major company is allowing people to get called the N-word, or you're keeping the employees after they do that to somebody, it might not look good. People may not want to use your service. So, we settled, we got a decent amount for that. So your remedy is to sue. I mean, that's really what it is. If they do the wrong thing, your remedy is to sue. Now, you hopefully you can find a lawyer that's willing to do it. If not, you go to those state agencies or those government agencies and hope that they'll follow through on it.
Can I ask just two more questions?
Yeah, go ahead. I'm fine. Go ahead.
Okay. One is, is there a ratio to how many men to women that are harassed? I mean, does it seem like, I would think, oh, it's almost a lot of women, but is it equal parts, or
So,
heavy male?
so people who call my office, now keep in mind, there's different types of harassment, right?
Right.
So if you're talking about sexual harassment, then it's almost exclusively, I would say 95% of the calls I get are from women, if you're talking about sexual harassment. And in that other 5%, you actually, it's typically, I have had men who are getting harassed by other men, right? Homosexual men. I've had men that were getting harassed by women. It's rare. And typically it's when the man doesn't find the woman that attractive. Every now and then you get the guy who's married or in a relationship and he doesn't want to, he's not happy with it, but typically he's not attracted to her. But yeah, this woman was not, he was not interested, and he was happy in a relationship and she was coming after him, and that was part of his overall claim. He had a lot of stuff going on, but it's typically women dealing with the harassment when it comes to sexual. Now you have men though, who are harassed because of race. My client with the company, when he was getting called the N-word, they were, making, racial jokes and whatnot. It was a guy. You know what I mean? So, and you get people quote unquote locker room talk. No, we not. Listen, with stuff that occurred in high school locker rooms is not allowed in the workforce for the most part. You know what I mean? And so it's not just excused as okay. And that happens to men and women, I would say, but equally. The discrimination, obviously, men can't get discriminated because they're pregnant, right? Because they don't get pregnant. But for the most part, it goes equally, I would say. Although I would say probably the majority of the calls I get are from women, because a lot of men are like, well, I don't want to report that. How do I look if I'm reporting that? I'm a man, I should be able to tolerate this, what kind of, and that those are the stereotypes that we deal with, gender stereotypes, and men not wanting to report things because they want to be macho or be considered manly.
And then my other question is, if you're in, because I've been in different employers where, like I've had the union as an option. I've had, not not that anything's wrong with my current employer, but
Of
where
course, right? Past employers.
there's also like an HR type of thing. Like we have our own little like admin HR within our company, but like there's another company that kind of oversees certain things and can do disciplinary action. Is that where you should really start and not just, okay, this happened, I'm jumping to an attorney? Or should you try to remedy it within the company before you jump to an attorney?
So remember, you have to report it within the company first. I mean, for the majority of cases, right? If a woman is raped by a coworker, she don't have to report that to the employer first. You go to the police, you go to, right? I mean, that conduct is so over the top. But, oh, he keeps asking me out. He keeps, talking about my body. He keeps doing this or that. You have to report that. So you have to go to the employer first, because if all these things could happen for a year, but if you never report it, you can't sue the employer for failing to correct a problem that the employer never knew about or wouldn't have known about other than for you telling them, right? So you have to put them on notice in order for them to be responsible, because the way it works is the law, we want employers to do the right thing, but in order to do the right thing, they have to be on notice. So you have to tell them. Now, if the conduct doesn't stop, that's when you could look to going to a lawyer. But initially, I mean, I've had people call me, right away. I'm like, okay, have you reported it? Well, no, I wanted to talk to a lawyer first. I said, okay, I appreciate you calling me, but you got to report it. If you report it to your employer and, Bob doesn't stop, asking you out on dates, or you report it to your employer and they keep calling you racial slurs after you reported it, and they don't do anything about it, now we can go after them.
I guess my question is like, I mean, I worked for like the county before,
Okay.
and then, but we had a union. So
Right.
would it really be, okay, so I told my supervisor, oh, like the pregnancy one, I worked for the county at the time, but we had a union. Would it have been, okay, I reported it to my immediate supervisor. Should I have then should I have then reported to the union, or should I have talked to an attorney first and try to go the union route because we have, I have those protections there? Or is it, okay, I just go to an attorney and bypass the union?
So typically in your MOUs, your memorandum of understanding, right, between the union and the employer, there are certain requirements that you're required to follow, right? You're in a union company or a union shop, if you will. So as an employee, there are certain union rights that you have to go through, right? Give them the opportunity, right? The part of that is when you're giving them the opportunity, right? If you're a union member and you're reporting something, typically the union's going to be put on notice of it anyway, right? So the union will be on notice. Now, if I've had people call me and the union not doing anything. Well, so basically you had to give the union the opportunity not to do something, and then you can look to get an attorney, assuming you're depending on what your MOU says. For the most part, you could still go outside of the union and sue the employer separately. You don't have to go through the union, but you typically do have to. I should say that you typically have to put them on notice and at least try to go through them first. And that doesn't remedy the problem. Now you can look to sue. It kind of adds an additional step in the process, right? I reported it to my employer. I reported it to my supervisor. It didn't get fixed. Now you go to the union and let the union try to work it out, negotiate it. And I will say this, one thing is about unions, right? Unions, you got a better chance of getting your job back, right? I mean, because the union rules require a lot more proof of misconduct in order to let you go than the at-will employment laws in the state, right? I didn't mention that either, but employment in California and in most states is at will. They hire you because they want to hire you, and they let you go because they won't let you go. They don't have to give you a reason. They just can't terminate you for an illegal reason, that we talked about. Same thing with you though. If you want to quit, you just quit, right? There's nothing forcing you to keep working for them. So it's not, you can't force them to keep you, but they can't force you to keep working there. So it has to be, equal. And keep in mind, for the, 1% of employees who are hired like as CEOs and CFOs and they're on an employment contract, those are different rules that may apply in terms of termination, um, um, and your job duties and whatnot, because you're on that contract. If they fire you, they got to pay you out.
Yes.
Kind of like, baseball managers or basketball coaches, right? You got a 5-year, $10 million, 5-year, $20 million contract. They fire you after 2 years, they got to pay you out. I mean, because you're on a contract.
Well, no, this has been great because again, I should be on a beach somewhere with all this stuff. But no, I mean, this is what our audience really needs to hear because it does go on, and it does happen. And what you can and can't do, especially with, depending on the type of employment, we talked about unions, or if you're in terms of documentation and citizenship. So, no, I think that is really great. I really do appreciate the conversation.
Yeah, I'm looking in the group. I'm looking in the group in the chats. People are saying great conversation, good information, not really questions. So I guess like you're covered a lot of the stuff. One of the other things, it seemed to be a uprising. I seen an article, workplace bullying. Is that
Mhm.
considered just harassment? But I'm seeing a lot of people talking about this workplace bullying, how CEOs, management are just like bullying employees. What's your thoughts on that? Is that like a big problem, or is it just kind of a
So when you say it's a big problem, I mean, it occurs, right? I mean, and that is harassment. Bullying goes beyond the average or the normal kind of like office shenanigan type stuff, right? Bullying it could be threats, it could be just, like coercion, it could be, I mean, it happens, people making fun of you for certain things. Maybe you have a speech impediment. Maybe you have, whatever, and they just doing it constantly, daily. You know, um, I had somebody tell me they'd walk past like in front of them, like she'd be walking, they walk like right in front of her, like purposely, like to almost hit her, right? Or she got shoulder blocked before by an employee. Right? I mean, that type of stuff. So it's I mean, workplace bullying is not legal. Workplace bullying is harassment. I mean, there isn't a specific workplace bullying term in the labor code, right? Or the Fair Employment and Housing Administration code. But I mean, it's harassment because it's objectively harmful, right? You feel it. I'm sorry, subjectively, you feeling it, and objectively, the average reasonable person is like, no, that's not right. So, I mean, you have in the last few years, the main things that have kind of been on the rise. It's not that it's been on the rise in terms of occurring, it's been on the rise in terms of being noticed or being called out, is bullying and the Me Too, bullying and sexual harassment. The Me Too movement, which got a lot of people fired, right? Who should have been fired, right? Because they were getting away with murder. I mean, just the stuff that was going on Fox News, for instance, with Roger Ailes, right? I mean, then you find out about the stuff that CEOs are doing, and CFOs at MGM, so it's been going on, and luckily women decided they're not taking it anymore, and more importantly, they're putting people on blast, right? They're putting it out there, and then because it's been going on, but what's happened is there were a lot of settlements, right? Financial settlements with non-disclosure agreements, which in California, they just passed a law that you can't require that that's not allowed. Non-disclosure agreements in sexual harassment, there's something to that effect. You can't require that as part of the settlement. So now the information will get out there, and people can't be a serial harasser like Harvey Weinstein or Roger Ailes, some of the famous ones, right, that we've heard about, or Bill Cosby. Oh, I might have offended some people with that one,
wow.
but where there's smoke, there's fire. You don't have 50 women saying that you did this and you didn't do it.
Right, definitely. So as we get closer, and then one other thing, I know you hit a little bit about our elderly people.
Mhm.
And, we know that our baby boomer generation is retiring, and I know there's still a lot of people over the age of 40, still trying to apply for work. And I know a big thing is trying to um, prove these things, how to, like you talked about the raises or the promotions. How does it, if a person know, like, hey, I'm working in this department, I'm the most senior person, or I have the most experience, but I got bumped for this younger person, or how do we help those people out, Justin?
So, I mean, I get those calls too, right? And unfortunately, when it comes to lawsuits, it's not what happened. It's not about what happened. It's about what you can prove happened, right? Yeah, you got passed over. You got passed over by somebody you feel was less qualified. You feel somebody got promoted because, or you didn't get promoted because you were Black. They got promoted because they were white or because of whatever their race or their group was, right? But you got to prove it, you know? I mean, if you're the only Black person in your department, anytime something happens to you, you may feel it was racial. It may even be racial. But how do you prove it when you're the only one, right? Now, if there's, let's say there's a department of 30 people and there's let's say there's 10 Blacks, right? A third of the department is Black. And you had like 5 promotions come up. Nobody Black, despite being there at being the most senior, nobody Black got it. Well, now you got a large sample size to argue, right? And you could represent all of them, or at least if you're representing one, you could at least use the others as examples. When you're the only one, it's difficult. There's not going to be an email, don't promote Justin because he's Black, or promote Becky because she's white instead of Justin because he's Black. You're not going to have those emails typically, right? So they it's hard to prove. I mean, like I said, you got to be able to prove it. How do you prove it, right? I mean, how do you? And that's the hard question. And a lot of lawyers like, what proof do you have? People like, well, I'm hiring you. No, we can't. We don't get to find the proof. It kind of needs to be there. I mean, we could try to find it, but it's difficult. Now, if you have coworkers, let's say your coworker who's a friend of the family, if you will, right? They're not Black, but they like you. They're your friend. They'll say, hey, uh, you know, Joe told me that he was gonna hire Tina instead of you, even though you're more qualified. He doesn't really like Black people. You know what I mean? If you got a witness, right? You need witnesses. You need, what's it? Can I get a witness? Right? You need, you have to have some proof, whether it be written documentation, a text message, an email, or a witness who says that who is willing to testify, right? I don't know how people I've been told, well, Bob knows this, Bob will help me. I call Bob. Yeah, no, I don't want to participate in that. I'm not sure what she was talking about. So you got to have a witness. I mean, you got to be able to prove it. You may know it, you may believe it in your heart, and it very well may be true. But if we can't prove it, what are we gonna do? Right? I mean, if you're one person, there's a small sample size. So it's difficult. Somebody in the chat pretty much asked a question similarly about that, right? Racial bullying or systemic, or you're being constantly overlooked or constantly devalued. Well, you got to prove that it's due to your race or your gender or your sexual orientation. I mean, if the workforce is 50% female, but the promotions are 90% male, well, you got a large enough sample size. But if you only got 2 people going for the promotion and one's female and one's male, and it typically the male gets a promotion, well, that's not enough. That's not enough of a sample size. Or if you got one black person, one white person in the white person, okay, well, you maybe you were more qualified in your own opinion, but the question isn't, the question was the other person unqualified? If the job requires a master's degree and all they have is a bachelor's, but you have a master's, well, now we got something there, right? They didn't meet the minimum qualifications. Now you may have something there. That would be evidence that they didn't follow their rules. That'd be evidence that they were less qualified than me because I meet the minimum qualifications and they didn't. There you have something potentially.
Wow. I'm glad you explained it that way. I know a lot of people had reached out before you came on and talked about the discrimination. And yeah, we know that's hard to prove. You know, if you have a large employer, if you work for a large city entity or a state entity, they're going to hide under those, uh, you know, prove it. You know, we how you
Right.
say is discrimination, and we have all these genders and all these different people here. So it's a challenge, and we know individually things do happen. And I think that's one of the biggest struggles is trying to prove it. But definitely unfortunate for the people. But definitely glad to have you come on, man. We don't want to take up all your time. We're looking forward to you coming back. I know you talked about some future presentations in the future for our people. Now you have been on here. You've been on both sides of the conversation. The Ward firm. He's here in California. What's your demographics? Are you just in Sacramento? Or are you over the?
So I mean, my main office is in Sacramento. I have a satellite office in the Bay Area that I use at times. But if it's a good case, I'll go anywhere in the state and even out of state. I have cases in Washington, D.C. I got a case in Texas. I got cases, very a few cases here and there throughout the country, if it's a good enough case, right? I mean, obviously, you work at a place for 5 weeks and then they let you go and then, you want to sue and but you only had 5 weeks there. So your case value isn't much. I'm not taking that case in Florida. It's not worth it, right? All the requirements and different things. I mean, things are a little easier now because everything is remote, right? And depositions are being done remotely and whatnot. But yeah, so I handle primarily in the Sacramento area, but all throughout the state for sure. And even if it's a big enough case, if I find out that some major retailer or major employer has been not paying overtime and people have been working, they've been working 10-hour days every day for the past 3 years, and you got like 50 employees and it happened in Maine, oh, I'm going to be taking that case in Maine because that's, a very good case.
Wow, that's cool. I'm glad you explained that because sometimes people don't know. Definitely, I just want our people to know Justin is definitely, y'all see how he brought the information to you, transparent, um, relatable, um, and that's what we need. I mean, I'm glad you was able to come on because a lot of times we are trying to find in our communities someone that we can relate to, kind of understand, that can help us through these processes because they are difficult and complicated. And if you don't know, or you don't have the right representation or somebody to give you the right information, it could definitely put you on a cliff or a pitfall. So just glad you was able to come on tonight, man. We appreciate you, brother. This is a good brother. So definitely if you have some other questions, he put up his information. Please reach out to him, the Ward firm. Good brother here. He just put his number in the chat. But please, reach out to him and ask. And like he said, some things he might not be able to help with. But definitely reach out to him. I mean, it's a great resource, and I'm just glad the brother was able to volunteer his time to come educate the people. Y'all know here at both sides of the conversation, our educational Thursday is about elevating our community, uniting our community, and getting people like Justin to come back and educate our people. Because a lot of times what happens in our community is people go to school, they get their master's degrees, they get their PhDs, they start climbing the corporate ladder, and they forget about the people below. So here you can see a brother that's genuine from the heart, giving back, coming back, trying to let his people know. And definitely want you guys to reach out to him, because that's what it's about. And we're trying to unify and educate our people in the community with our Educational Thursday, because we understand the gap of wealth, the gap of disparity is all through information. So having Justin come on to give you guys that information, we can now close that loop. You have a resource. He already said some things he's not going to be able to deal with, but definitely want you to reach out. Maybe you have a case, maybe you have opportunity or something to look that might be beneficial, or at least he can guide you in a way that you might be needed, and help you out. So just want to thank you again for coming on both sides of the conversation. Everybody, we getting ready for this Sunday's conversation at 2 p.m. We're going to have an amazing conversation with our Black and Brown military service people. We have some amazing guests going to come on, and we're going to get in-depth conversation about our Black service people, how as a community we can help them, some of the things that they need help on, some of the amazing things that our veterans, the VA is doing for them, some of the things that they're not doing for them. There's a couple of things we've been putting in our group information out there. We want to get you guys' opinion. So if you could tune in this Sunday at 2 p.m., it's going to be a great conversation for 2 hours talking with some of our veterans. We also want to salute them for their service, because we know a lot of our military people in the Black and Brown community, they don't get the honors that they deserve. So we want to highlight them and have an amazing conversation. And then following that, this Tuesday, we're going to have another amazing show of our hidden gems. So please tune in so you can see this week of hidden gems in our Black and Brown businesses. Again, we want to promote our businesses. We want to spend our dollars and circulate them and patronize our Black and Brown businesses. Just like this brother Justin, we want to get people to patronize our brother. And so thank you guys for coming on tonight for this segment of Educational Thursday. I am the co-founder of Both Sides of Conversation, John Henry. I'm with Asia Pullen, our executive administrator that's doing all the amazing backseat, back work. She was able to join us tonight. We want to thank her. Thank Justin for coming on. Please reach out to the brother. We will replay and circulate this video. And also, please check our YouTube channel out. All of these Educational Thursday series will be put on our YouTube. All our previous conversations will be on there, and all our hidden gems will be posted on our YouTube video. Also, we are still looking for mentors for our women mentoring group. So if you are a woman out there and you are interested in doing some virtual mentoring to young women ages 14 through 25 years old, please reach out to us at both sides of the conversation at Gmail. We are trying to get our mentors in line so we can start grabbing these young ladies and educating her and working with our young ladies in the community. So with that being said, thank you guys again for tuning in. Our co-founder Rico is out handling business and meetings. He wasn't able to make it tonight, but keep him and his family in your prayers. And we love you guys, and we see you guys on our next Educational Thursday.